Hey, I'm Paul Rabelais, and this video is all about requesting that banks, credit unions, and brokerage firms stop asking for letters testamentary or letters of administration when a customer or client passes away and the survivors come in attempting to settle the estate. I'm Paul Rabelais, an estate planning attorney. This is really relevant in Louisiana. Here's the situation. Somebody passes away, they have accounts at a bank, credit union, or brokerage firm. I'll lump those together and call financial institution. They have accounts at a financial institution. Their spouse, their child, their loved one goes to that financial institution and says, hey, my father passed away. He had some accounts here. I'm here to settle his estate. Banker typically says, I'm sorry, we can't give you any information. Your father's account's frozen. We need either letters testamentary or letters of administration in order to give you access to those funds. So they write that down. What do we need? Letters testamentary. Okay, I'll be right back. So they leave the bank, they call our office, they make an appointment, they come in with their little sketchy pad. We just went to the bank and we need letters testamentary. Can you give me one of those letters? And so then we have to go through a kind of an educational exercise. We have to get them to realize that, it's not quite that simple, and what the bank is asking for really isn't what we're going to be providing you to get access to the bank accounts, and it's all, subject to a court supervised procedure. So here's the deal. Back in 2001, many years ago, the Louisiana legislature authorized a relatively new kind of independent administration of estates, allows estates to be settled with less court supervision than was required under the previous rules. And it happens, this independent administration happens when either the will authorizes it. The will might say, I name Fred as the executor, and my executor may act as an independent executor. And virtually all wills since 2001 authorize that because nobody wants more court supervision than they need. And even if the will doesn't authorize it, all of the heirs can agree to allow the executor to be the independent executor. So it happens almost in every situation. And when that's the case, and we file all the court pleadings to get the executor confirmed, the courthouse doesn't issue what's called letters testamentary anymore. They issue what's called letters of independent executorship. By the way, if there's no will, the courthouse doesn't issue letters testamentary. They issue letters of administration. They issue letters of independent administration when there's no will and all of the heirs agree that the administrator can act as an independent administrator. So in almost every case, we've got to say, yes, your father had a will, he named you as the executor, the bank says you need letters testamentary. I know you don't want to go to the bank unless you have those letters testamentary in your hand, but you're not going to have letters testamentary. You're going to have letters of independent executorship. And so it just causes a lot of confusion among surviving family members, hard enough to handle what they got to handle. And so this is just my little suggestion to the financial institutions, particularly those with clients and customers in Louisiana, to stop requesting we need letters testamentary, or if there's no will, letters of administration, and say something like, you'll need to see an attorney and get your letters of independent executorship or letters of independent administration, or in the unlikely event that there is not going to be independent administration of the estate, then you can bring in either the letters testamentary or letters of administration, but that's rare. So just a terminology thing. We get involved in settling these estates, and when financial institution is telling them one thing, we're telling them another thing. They don't know who to trust. They don't know what to do, and it just causes more stress, delay, confusion when there's already all of that going on in the first place because you're trying to settle an estate with many different moving parts. Hope that helps. Y'all take care. Have a great day.